if you're in my office and I tell you to leave and you say I don't feel like leaving yet, I'll say if you're not going to leave, I politely ask you to leave. If you're not going to leave, I'm going to shove you out. That's a conditional threat. Your apprehension is not reasonable. Why? Because I'm entitled to control who's in my office and who's not. If we're in your apartment, I show up and tell you to get the hell out, or I'll hit you. Now your apprehension is reasonable because I have no right to impose that condition that you leave. So watch out for conditional language. Decide whether the party speaking it had the right to impose the condition. That will likely mean no reasonable apprehension. Or they did not have the right to impose the condition. That will likely mean the apprehension is reasonable. You may have other facts that drive it one way or the other. Again, I'm mentally unstable. I've asked 3 students to leave and I've hit 2 of them before they had a chance to leave. And I go to you and say, get out of here right now or I'll hit you. You're fearing that even though you're getting up to go out, I'm going to hit you anyway. It may be rational, even though I've got the right to tell you to leave. So you look for added facts in those situations. So watch out for negating language in an assault fact pattern. Watch out for conditional language in an assault pattern, and know how to handle each one correctly. Remember, none of these things require us to cause the touching and a battery directly, the apprehension directly. It can be indirect. You go home tonight and I put a rattlesnake in your bed. You pull the covers back and you're terrified. The snake actually never bites you. You can sue me for assault. I've got conduct that caused you apprehension of imminent battery. It does not have to come from the speaker or the person who engaged in the conduct. As long as my conduct causes you directly or indirectly fear of an imminent battery, then the court's going to be satisfied with those elements. So it can come from third-party sources or from snakes or whatever. As long as my conduct caused you to be apprehensive of an imminent battery. In that case, if I put the snake in there, my conduct did cause you to be apprehensive of an imminent battery, and I intended it. Again, with damages, I don't think you'll have any damages. You can't be tested on the damages here, but remember, you might be. You get any damages called by the assault. What's the ordinary damage in an assault case? The ordinary damage in an assault case is the emotional distress caused, the apprehensiveness, the terror, the fear, the irritation. You get damages for that. So you've always got some damage in an assault. It may be very, very minor, but you've got some damage because it's the emotional distress that's been caused. But let's say I scare the hell out of you in a way that makes you fall down and hurt yourself. Well then, even if you sue me only for assault, I can get the damage of the broken leg. Why? Because it was my conduct scaring you that brought about the broken leg, if the facts justify that. So you get all damages caused, same with battery, by the wrong I committed against you. So you may have to analyze both assault and battery in that case. Mentioned that the damages were caused actually by him making him apprehensive. But if they sue for battery, where I never intended that touching between your legs and the floor, you use transfer intent. You'll succeed on battery. Now what do you do if you can succeed with either one? Can you skip one of them? Because you brilliantly handled one. The answer is no. You got to analyze and explain both. Why? Because how do we know what the plaintiff's going to sue you for? So if you're working for me, I want to have all the torts laid out because I don't know what they're suing for. So we're going to analyze all of it. So the same fact pattern may give rise to 2, 3 different torts. You have to analyze all of them. Okay, false imprisonment. Again, the magic phrase, conduct intended to cause and causing. In this case, confinement of the plaintiff without consent, privilege. Simple. You look for volitional conduct. If it's obviously volitional, you don't even bring it up. You got conduct. What do you look for next? Did the conduct cause confinement? After you've shown that the conduct does cause confinement, you ask yourself, did the defendant intend to cause that confinement? When you're on intent, again, don't jump right into purpose, knowledge, or transferred intent, first, state the law of what has to be intended for this tort. Confinement. That will keep you focused on whether confinement was the purpose. Or if confinement was not his purpose with his conduct, he knew to a substantial certainty the person would be confined when he engaged in that conduct. And if neither of those work, go to transferred intent. Again, don't lay out all the law about purpose, knowledge, or transferred intent. You never need to bring up knowledge or transferred intent unless purpose hasn't worked. Purpose works everywhere in the fact pattern, and I'll never hear about transferred intent. You use them when you need them. You'll need knowledge to a substantial certainty when purpose or desire doesn't work. You'll need transferred intent when neither purpose nor knowledge works. So the issue will be, do we have conduct causing confinement? Did the defendant intend that confinement with the defendant's conduct? Is there consent? Here, you've got to have memorized how many ways the courts will accept as proving confinement. Many people may feel confined, and they may reasonably feel confined, but the court won't from defendant's conduct. The court may still say, you haven't proved confinement. They only accept a limited number of ways of proving confinement. The first and obvious one is physical confinement. You're locked in. You're physically confined. The facts will show that. With physical confinement, where I lock you in, the facts that I lock you in show that you're physically confined, unless you got to keep some other law on the side. You've got a reasonable means of escape. I lock you in room 201 by locking that door. If the other door is unlocked, you have a reasonable means of escape. I lock both doors such you can't get out. So now you're physically confined within space. Do you have a reasonable means of escape? You can climb through, you can move these panels and climb over that wall, maybe with a little help from your classmates. That's not a reasonable means of escape. Anything that greatly inconveniences you or puts you in danger of any physical harm or great inconvenience is not considered a reasonable means of escape. So it's just another reasonable person test. That amounts to physical confinement. Well, very often false imprisonment is not, you're not physically confined. I'm telling you, stay here or I'll shoot you. That's not physical confinement. You're free. You're physically free. There's no physical boundaries keeping you in. That's a threat of force. The courts accept threat of force if a reasonable person would feel confined by that threat of force. So now you got a reasonable person test. With physical confinement, the reasonable person test was means of escape. With threat of force, it's would a reasonable person feel confined by that threat of force. If the person who's threatening force, telling you to stay there or they'll shoot you, is paralyzed and doesn't have a gun, your feeling of confinement is not reasonable. You wouldn't be able to prove confinement, even though you got a vicious threat of immediate force. So if you're using threat of force for confinement, attach it to a reasonable person would feel confined by that threat under these circumstances. Depends on the circumstances. The threat of force, remember, has to be threat of immediate force. I say stay here for the next 10 hours or in 2035 I will hit you. That's a threat of force. Even if you don't even argue whether a reasonable person would feel confined. The courts have already decided it. It's got to be a threat of imminent force. Threats of future force, the courts say, deal with it another way. Don't deal with it through false imprisonment. So a threat of imminent force that confines someone and a reasonable person would also feel confined will meet that approach to proving confinement. So you got physical confinement, threat of force. Now, threat of force that we just talked about was a threat of force against your person. Threat of force against property will work also. Threat of force against a third party will work also, if a reasonable person would feel confined by that threat of force. So threat of force against person, threat of force against property. So I say, stay here for the next 30 hours or I'll snap your toothbrush in two. That's a threat of force against property, but no reasonable person would feel confined about that. If I say, stay there or I will crush your $400,000 diamond under my heel, that's a threat of force against property that would confine a reasonable person if they had a possessory interest in the diamond.